This is Michael Popok with a Legal AF hot take and a viewing guide for next week's United States Supreme Court oral argument on whether a major piece and a feature of the prosecution against Donald Trump, two of the four counts in his D.C. election interference case for obstruction of an official proceeding, are going to get tossed by the United States Supreme Court because they're going to find perhaps that the obstruction of justice count under our criminal code was improperly used by the prosecutors where they overcharged the indictment. And if they make that decision, and I'll give you all the analysis so that you can listen to the oral argument, which we'll have on the MeidasTouch network, with informed ears, so to speak. If they do that, Donald Trump will be left with the prosecutors will be left with just two counts against Donald Trump for election interference and conspiracy in the D.C. election interference case that's currently on hold, subject to another oral argument in the United States Supreme Court 9 days later on the 25th of April about immunity. But more, as importantly and as devastatingly, if the Supreme Court sides with the trial court judge, Judge Nichols, and against the D.C. Court of Appeals and their ruling led by Judge Pan, if they side with the trial judge, 300 already prosecuted, many of which have already been convicted, some of which have already been sentenced, will have that charge vacated and reversed, meaning they'll have to be tried again without that charge, or they're going to be set free. That is how devastating this could open the floodgates. I don't mean, as I say, I don't blow smoke or sunshine here, but this could open the floodgates to have 200 or 300 people released from the criminal justice system who committed these crimes and these acts as alleged on Jan 6th. Let me break it down for you so that you understand it and what I'm talking about. And let's first talk about the messenger for this case. Who's bringing this case to the United States Supreme Court up from the trial court level with Judge Nichols through the Court of Appeals level, three-judge panel led by Judge Florence Pan. She's the one that also wrote the immunity decision against Donald Trump. And now the United States Supreme Court. Joe Fischer, who had been a police officer in Pennsylvania, decided he was going to literally lead the charge and attack on Jan 6th. He wasn't just a accidental tourist. This wasn't like insurrection tourism. He actually was one of the leaders. Probably his police background came in handy there as he did battle in hand-to-hand combat with Capitol and Metro Police and led the charge against the line that was trying to be held by the Capitol Police back in the West Portico and in other areas in breaking in. And on his social media, he made it clear his intention was to stop the steal or stop the certification of the election by and the counting of this electoral certificates by Congress. I'll give you two quotes from him that are in the paper submitted by the Justice Department. This is from Joe Smith himself. He said, Congress people can't vote if they can't breathe. There's one that indicates that he wants to stop the counting by killing elected officials. He also said, to be clear, let's take them to the gallows. He wants to hang and assassinate, disable, maim elected officials, congresspeople, to stop them from counting the votes. That sounds like obstruction of an official proceeding to me. The count that we're talking about here, which is under the criminal code, 18 U.S.C. 1512. 1512, there's two sections of it, C1 and C2. C2 is the charge here, that they are obstructing with the official proceeding, right? Specifically, and I'll read it to you, that they are obstructing, influencing, or impeding an official proceeding. The official proceeding is the congressional counting of the electoral certificates, and they tried through their actions to obstruct, influence, or impede it, right? Try to make it harder to do. Seems pretty clear to me. But to Judge Nichols, the trial court judge, and now Joe Fischer and his lawyers to the United States Supreme Court in their briefing, they say you have to look at 15C2 along with 15C1 and how Congress passed this law and what this law was intended to do. In other words, you can't leave it unmoored from its foundations. And the reason that law was passed in the 1990s was about things like the Enron scandal, where a company sort of went up in smoke and its auditors, then Arthur Anderson, hid documents. And therefore, there are two sections that were passed as part of the Sarbanes-Oxley laws about financial crime. Yes, financial fraud. I understand the original title. And if you read 15C1, it prohibits the tampering of evidence, right, with the intent to impair an official proceeding. So tampering of evidence, ripping up documents, destroying documents, flushing them down the toilet, erasing them from computer servers and drives. That's 15C1. But 15C2 doesn't say you got to have evidence tampering. It's a catch-all. It says if you do anything corruptly, willfully, wrongly, to impede or impair an official proceeding, you're also guilty. Now, to Joe Smith and his lawyers, and to Judge Nichols at the trial court level, yes, I agree, you have to read them together, but they're hyper-focused on the word, some words of the text that suggest that they go together, that you've got to have evidence tampering, literal evidence tampering, in order for you to be able to use the impeding and obstructing an official proceeding provision in 15C2. In fact, Nichols even used an oral argument in his writings, in his opinion, that effectively Joe Smith would have had to put his hands on the electoral certificates that were being counted and rip them up in order for this provision to apply. And they continue in their brief to argue that the prosecutors have misapplied this law. This law was on the books. Congress sets the law. This is our co-equal branches of government and our checks and balance system, right? Congress sets the criminal law, and they would never have foreseen that the law would be used under these circumstances. Now, what Justice Pan said for the 2-to-1 vote in favor of reversing Judge Nichols and finding that the Department of Justice properly used 1512C2 to charge people like Joe Fischer and Donald Trump, is like the prosecutors couldn't envision exactly the fact pattern on Jan 6th that the fellow Americans would attack the Capitol to try to stop the peaceful transfer of power. But the prosecutors are not foreclosed from looking through their statute book to try to find statutes on the books that apply to the crimes. And yes, it's under the financial fraud section, and this wasn't financial fraud, but it doesn't mean you can't use it in more unique and creative ways. I mean, look, the Racketeering, Influence, and Corrupt Organization Act was passed in the 1970s by Congress, RICO. It was supposed to be done for organized crime. It's been used for every type of financial crime involving companies, corporations. They stopped using RICO against mobsters and the mafia, 20, 30 years ago. But that hasn't stopped the understanding that you could use these laws, even though it originally was passed for one purpose, for a new purpose that's arisen. I mean, prosecutors are stuck. You can't create a new law, let's have a attack on the Capitol by insurrectionists act. You have to use anything that's on the books right now as part of your charging document. Ever try to break a bad habit and felt like you're climbing Mount Everest in flip-flops? Yeah, we've been there too. But here's a breath of fresh air. Fume. It's not about giving up. It's about switching up. Fume takes your bad habit and simply makes it better, healthier, and a whole lot more enjoyable. Fume is an innovative, award-winning flavored air device that does just that. Instead of vapor, Fume uses flavored air. Instead of electronics, Fume is completely natural. And instead of harmful chemicals, Fume uses delicious flavors. You get it. Instead of bad, Fume is good. It's a habit you're free to enjoy and makes replacing your bad habit easy. Your Fume comes with an adjustable airflow dial and is designed with movable parts and magnets for fidgeting, giving your fingers a lot to do, which is helpful for de-stressing and anxiety while breaking your habit. The first time I tried Fume, it was way more flavorful than I thought, and it feels very fresh. The look and feel of a Fume is very sleek. It's well weighted, perfectly balanced, and extremely fun to fidget with. Plus, Fume's just released a magnetic stand for your Fume, so there's no more losing it around the house. And it's built with fidgeting in mind. You can spin your Fume around on it. Start the year off right with the good habit by going to tryfume.com/legalaf and getting the Journey Pack today. Fume is giving listeners of the show 10% off when they use my code LegalAF to help make starting the good habit that much easier. Start the good habit at tryfume.com/legalaf to save 10% off the Journey Pack today. And particularly, let me just read to you this provision that we're talking about so you get a better sense of what the arguments are going to be at trial. We're focused on 1512 C1 and C2. And the focus for the defendants is on the word others or otherwise. Watch me. Watch this kind of trick of analysis. The statute says that whoever corruptly, 1, alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding. What does that mean? There's an official proceeding, an investigation led by the FBI or another department. They ask for documents from somebody, and that somebody alters, destroys, mutilates, or conceals that piece of paper. Evidence tampering, evidence destruction. That's clearly, we all agree with that 1512 C1 requires the actual alteration, destruction, mutilation, or concealing a record. You hide it, you change it, you destroy it, or you change parts of it, or you mutilate it. Try to burn it. Okay, we got that. None of that happened on Jan 6. They did a lot of really bad things, including trying to assassinate members of Congress, but they didn't do that. But 15C2 starts with, there's a reason Congress wrote more language. They didn't just put a period at the end of that. They kept going. 15C2, which is the provision at issue here for the Supreme Court next week, just that provision, starts with otherwise, obstructs, influences, or impedes any official proceeding or attempts to do so. Listen to that again. You don't have to have gone to law school. This is just a lay, good faith analysis for a reasonable person reading the statute in English. 1 is the alteration, mutilation, right? Then it's connected to 2 by the word or otherwise obstructs, influences, or impedes any official proceeding or attempt to do so. And that's what we have here. We have the otherwise obstruction, the otherwise influence, the otherwise impede. I don't know how you can read this in good faith, the way Judge Nichols did or the way Joe Fischer's lawyers are arguing it, to say that you've got to have mutilation and destruction of evidence plus other acts to obstruct, influence, or impede. It doesn't say that. First of all, it says or. It says or otherwise obstruct. Or otherwise obstruct, given its normal lay meaning. Webster's dictionary meaning means, all those things I just said in 1? Okay? That you're definitely going to jail for. But you can do other things that otherwise, in other ways, obstruct, impede, impair an official proceeding, and you're going to jail for that too. That's the catch-all. This seems so reasonable in terms of an argument. I can't believe it's taken hundreds of pages of Department of Justice filings and filings by Joe Fischer to get up to the United States Supreme Court. But they're going to have to make this decision. And we're going to see early on how they apply the law. Now, I can tell you one of the things to look out for during the oral argument, and that's why this is sort of a listening guide. Listening because we only get the audio. There's a 2015 case at the United States Supreme Court that everybody likes to cite called Yates versus the United States, which basically says when you're interpreting a statute, a criminal statute, an act of Congress, that it should be interpreted, but not so broadly as to depart from the underlying purpose of the law. And if the underlying purpose of the law, the argument for Joe Fischer is going to go, was financial fraud, because it came out of the Enron days, it can only be applied in financial fraud situations. And you can't unmoor it, right, and untether it from its original purpose. Otherwise, it's become vague, ambiguous, unconstitutional, and you can't apply it to my guy because he never would have known. One of the things that has argued, and I do agree with Joe Fischer, is that a person is supposed to know what conduct it may be criminal. He should be guided. It shouldn't be ambiguous. And his argument's going to be, because people are presumed to know the law, even though we've got dozens and dozens and dozens of statute books that no person nor lawyer can ever know or memorize. But you are presumed under the law. It's a fiction. You're presumed to know the law, and you have to abide by it. He's going to say, well, even if I went to that chapter and I went to 15 USC, 18 USC 1512 C1 and C2, there's no way I would have come away with the understanding that I couldn't, that I'd be charged with that and committed that crime because I was trying to lynch and hang congresspeople. Other crimes, sure, but not that crime. I mean, that's his best argument. Had I, let's just do this hypothetical. Play it out this way. Joe Fischer, before he marches on the Capitol and revolts against our peaceful transfer, he looks up all the laws to try to figure out if any of what he was planning to do is illegal. And he's well, I looked at that chapter, but that applies to financial fraud, and I wasn't doing financial fraud, and I wasn't going to tamper with any evidence or rip up the certificates that were being counted. I just wanted to kill congresspeople. That's his best argument. And so we're going to see early on how that Yates decision from 2015 gets applied by the MAGA right wing of the Gorsuches, the Kavanaughs, the Alitos, particularly the Thomases, as everybody struggles here to, Robert struggles here to kind of hold the center. Are they going to say, well, it really only arises out of a similar circumstances when Enron went down and their auditors got caught, and you got to have evidence tampering, and that's not here. That's not what Congress intended. They love sending everything back to Congress, especially now that MAGA Congress is in charge. So you could see where early on in this oral argument, we'll know when somebody like Alito or Thomas takes the lead and is like, is this really how Congress would have intended? Would you think if you went back to the legislative history, they would have intended that future insurrectionists as charged would have violated this particular criminal code? Shouldn't we go back to Congress and allow Congress to clarify? We're not judicial activists. Really? We're not making law. You're not? But this will be their argument. When they want to make law, they ignore congressional intent. They ignore where the statute comes from, and they just make their policy decisions in a way that's not very conservative at all. But when they don't want to do it, and they want to give a break to 300 insurrectionists, including one named Donald Trump, they'll throw him a bone by throwing out this application on all the indictments opening up the floodgates. We'll continue to follow it. We'll have oral argument. The different legal AF people like me will get on the air and we'll talk about it and analyze it. I'll know more when I hear the oral argument, but I wanted you to be prepared for this 18 USC 1512 argument, 1 and 2. Why it's the fallacies in it, to know about the Yates decision, to know about what is the argument. What did Judge Pan, who's very well regarded, although very junior, why did she, in a 2-1 decision, why did she rule against Judge Nichols and overturn this and do the analysis that I just did? She's very well respected, by the way, just to leave it on that. She just led a 3-judge panel, 3-0, to find no immunity. And I think the United States Supreme Court is going to find ultimately no immunity for Donald Trump for his criminal conduct while in office. She wrote that too. So this is really smart people. And for those out there, a little bit of a refresher course or reminder, the District Court of Appeals, the DC Court of Appeals, is considered like AAA baseball, where call-ups to the major leagues, the Supreme Court, often happen. It's a feeder program for the United States Supreme Court. One of the things that presidents like Biden look for in credentials when they have to fill a spot on the United States Supreme Court is if they have that credential. Were they on the DC Court of Appeals just before that? Merrick Garland, for instance, came from there, and he was supposed to be United States Supreme Court Justice under Obama. Ketanji Brown Jackson came from there. Many of them came from there. So this is an illustrious body. They're very respected by the Supreme Court. Maybe not all of the Supreme Court, but many of them. So we'll follow what happens. Are they going to side with Judge Nichols, a Trump appointee who made that decision to find that, unless the insurrectionists are ripping up ballots and certificates, then, you can't use this section, or are they going to side with Justice Judge Pan in how my interpretation just laid out on this hot take? So follow us on Legal AF every Wednesday and Saturday at 8 p.m. Eastern Time. Join us. You'll find out why we call ourselves Legal AF. We curate the top 5 developments at the intersection of law and politics, bring it to you with an analysis just like this one. And then I do hot takes like this only on the MeidasTouch network about every hour, it seems. And if you like my work, you can also find my work on the MeidasTouch YouTube channel. Go to contributors or playlists, and you'll find Michael Popok and about 1,300 of my videos right up into the moment, right at the moment, as we like to say. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.